It's via the television or the radio platforms.
Oh, okay. So you've already, obviously, there's an agreement that has been signed with those collecting societies.
Correct.
Is it the agreement that is referred to in the collecting society regulations provide for the requirement to sign an agreement? Actually, even Section 9 of Copyright Act does require the collecting society to sign an agreement with the broadcasters. And specifically, those agreements should deal with the fees that are payable. The current agreement that you have, which you have, do they provide for the fees, or is it currently a blanket agreement?
Sorry.
Yeah, no, the agreement that we have made available to the information regulator is the one specifically related to RISA. That is the agreement that we have furnished the information regulator together with the two addendums to that agreement.
Yeah. Actually, let me jump into that agreement quickly. So, because if you look at the that agreement, that's an interim agreement, right?
That's correct.
It's a written interim agreement. And it provides, I will not go into detail into the agreement. And this is specifically because Clause 6 of the interim agreement provides for the protection of trade secret. So the question that I'm going to ask will not go into the main agreement. That's a standard thing that for transparency. The agreement talks about that there's been obviously litigation between SABC and RIFE regarding the issue of payment of royalties. And that has resulted in SABC obviously agreeing to pay the money. What come up from the agreement is the fact that the payment of those royalties, it's provisional.
That's correct.
And which means it.
Mr. Sidiwe.
Chairperson, I specifically mentioned that I'm not going to go into the agreement. So maybe Leslie should have waited for the question first before he jumped at the object, because I not asked the question. The question that I wanted to ask, Chairperson, is only relating to the section in the Act that refers that where there's a dispute, of course, that's what I was going to. So if Leslie could have allowed me to ask the question before you object, because actually the normal process that you allow the question before it answered, then you object. So the question that I'm going to ask, Chair, is nothing to do with the agreement. It's in the legislation. That's just a background to say there's an agreement, but the legislation provides for the following. And I want to ask a question relating to the agreement, to the legislation, the Copyright Act.
Yes, I hear your question. I think, but his concern was that now the background is it's phrased, talking about his putting his client into perspective. But I mean, he has objected, rephrase that question and go straight to that point. What do you want to make in that?
Shall I actually go into the question now?
Yes, go to the question.
The question I want to ask is that in terms of Section 9 of the Copyright Act, where there's a dispute about royalties and the fees that are payable, the SABC, together with the society, are compelled or required to refer such to a tribunal or arbitration. I think you mentioned about the arbitration, that at some point you wanted to refer the matter to the arbitration. So what I wanted to check is that because you have not signed, and I'm asking this question, Chair, because this is about the rights of those people who have not received, who are alleged to be not receiving access to say, have you referred any dispute regarding payment of royalties to a tribunal or an arbitration?
The answer is no. We haven't. Is your question specifically in relation to the complaint that you're looking at, or is it a general question?
It's a general question.
Yeah, I wanted to come in. I think it should be a general question.
It is a
because
general
the
question.
CEO has mentioned that they've got various collection societies.
Yeah.
So I think that let's be general. Let's not talk about resale. Let's be general in terms of how we address that, so that we don't be specific to a particular collection society.
The closest we've come to referring a matter to arbitration, as my colleague Ms. Ochela pointed out, was in relation to a needle time royalty challenge between IMPRA and SAMPRA. We eventually resolved the matter without going the arbitration route. We have been similarly in the same needle time royalties, been in court, which is litigation that landed in the Supreme Court of Appeal, which related to the determination of the percentage due to collecting societies. Beyond that, I am not aware that we have referred a matter to the tribunal, no arbitration. Thanks.
Is there any intention by the SABC to refer this kind of dispute relating to the fees? And I'll tell you why I'm asking this question. Earlier on, Gabby from the union did indicate about the plight of the beneficial right owners in terms of element of accountability from the society, and I think the CEO did touch on that. Is there an intention from the SABC to do so in the near future so that the interests of those copyrights are protected?
Look, to be honest, there are continuous engagements with various collecting societies, and I do know that there is an outstanding issue with one collecting society, which we are considering taking to the tribunal to have the issue of the percentage resolved. We do not have the decision at the moment. It is still something that we will take through the approval structures to get a mandate to take that process forward.
Okay. Well, one of the questions that we asked the union just before you came in was with regard to the how the musicians benefit where under the blanket agreement that you have in terms of usage, but the evidence was that now the system is improving in terms, I think you mentioned as well that from the radio perspective, you do provide the playlist to the collecting societies. But the question is, if it's a blanket agreement, do you pay based on the playlist, or do you pay based on the agreement that you have to say on a quarterly basis you're going to pay so much as SABC in terms of blanket agreement, or do you use the playlist?
Okay, I think our group executive video entertainment would respond to that, and then anyone would come in there.
Thank you.
So effectively, we use music cue sheets in the video entertainment space, or playlist information. So all of the video elements that we create and broadcast have got, let's call it a tracking mechanism. So we can account for the actors that were used in that, the directors, the script writers, and the music used. We keep logs of those so that when we pay over the royalties, we can then also give a list of what we've utilized as well. Your earlier question, slightly different in video entertainment as to how do we start the agreement. In in my space, we don't. TV channels have moved from beyond playing out music videos as fillers. So we basically run back to back with commercials or promos and then into the program. But if we're seeking to use a particular piece of music, let me call it commercial music, we will then look at the agreements that we have in place to understand who represents that artist. We will then make sure that we have the rights. So is it broadcast rights, is it mechanical rights that we're looking for? And we'll make sure that that is in the agreement that we have before we exploit that content. We will then also ensure, as I said, at the end of the broadcast period, typically it's the end of the month, we will submit all of our cue sheets so that the rights agency is aware of what we have utilized on the TV platform. Most of our content on the TV platform is driven by our own composed music. So we sign separate composer agreements with artists to create something specific for the content that we have. But when we use a commercial piece of music, it's flagged in our system and we can report on that.
Thanks. In the radio space, as I had explained before, specifically when it comes to needle time royalties, we pay for what we have used, for what we have played on our platforms. Hence, we share our playlists with the two collecting societies, and they come back and they confirm that what we have reported to have been used does indeed belong to them, and then we park the ones that are not identified. So in short, we pay for what has been played. We don't have a blanket agreement.
Yeah. Maybe this question is related to Advocate Vanara, the one that is coming now. It's with regard to, maybe if you can explain to majority of us what is a blanket agreement. It kept on referred in most, when we conduct our pre-investigations, there's been mentioning about the blanket agreement that SABC enters into. And Chair, the reason why I've been asking the question, I do not seem to get the answer, but maybe the first thing you should have done is to understand what is a blanket agreement, then I can go to my questions.
Even me, I didn't need your time.
Yes.
I wanted to ask you what is, because it's a terminology that we don't know.
Yeah.
So I hear, is it needle time?
Needle time.
Yeah, and blanket agreements. Maybe if you can
Needles and
explain.
blankets.
Yes. Yes.
Maybe if you can start with the needle time first.
Yes.
I did ask earlier on, Gaby didn't do justice much. Come and assist. Okay, maybe you can hold actually this much.
Yeah.
I think that the best way to explain needle time is, to make an example of the record player, where you take a record, you put it on the player, and, that needle is what then, gives you the music. So if the needle has gone through that particular song, then it has had needle time. It has been played, it has been exposed to your audience, and that is what we pay for.
Okay. But that's mainly for in radio.
Blanket.
That's radio.
Okay. Let's hear the blanket.
So, a blanket agreement is, in the TV space is that from time to time we may use commercial music as incidental pieces to create an environment of some sort. It's not the full program, or it's not the full music video per se, it's not the full music, but it's just a little snippet of something that we are using. So we call it a blanket agreement that says we can use music as a rebroadcast. So we're not doing any mechanical changes to it, we're not reperforming it, we're using the original piece of music within something that has been broadcast. So typically we would have to, as the broadcaster or the user of that content, keep an accurate record, which we then flight back to the rights agencies to say this is what we've used under the blanket agreement. Remember I said earlier, if we want to mechanically reproduce that for whatever reason, we have to go back and see whether we have rights. And I suppose the challenge then comes in is when we do music shows, that's where the problem comes in, is now what rights do we have? We have to then go and acquire those rights separately. So if we do a music concert, if we do any form of live coverage of certain things, that's where the problem comes in. That's now not a blanket agreement. it's outside the blanket.
Okay, thanks a lot for that explanation. The question that come in from the blanket agreement is that you now have, and I think the evidence from the union, you now have people who are entitled to receive royalties. You've played their music, but they're not member of collecting society. The question that we have is that how, and that's why the people camp in your office, I guess. I know that may not be the main reason, but if a person is not a member of a collecting society, but you pay only society, I understand, and I assume, maybe you'll give me an answer, whether do you pay individual artists, those who are not part of the society, or you only pay the society? Maybe let's start with that question first.
Under the blanket agreement?
No, any other agreement here.
Okay, so if it's not represented, we do not use it. It's just too cumbersome to now go and figure out who owns the rights, how do you pay them, and then it becomes a problem. Remember, we are a Schedule 2 company, right? So you heard testimony earlier that we have to make all of our records available. How did you select that particular artist versus the rest of the independent artists out there? How did you give everyone a fair chance? So that's where the blanket agreement becomes beneficial for a broadcaster. We're trying to put stuff out to air fairly quickly. So we're working in under 21 days turnaround of something that we've got to put to air. To go into litigation around that becomes extremely important. So what we do is if there's something that we hear and our producers want to use it, we make sure that it is covered by an existing agreement. If there's no agreement in place, we then go to recomposing new pieces of music effectively so that we don't have the litigation issues.
One of the, I think, Department of Arts and Culture, in their common problems, they highlighted this aspect that I'm going to ask about: the rights owners whose music whose money is being collected by a collecting society, but the collecting society wouldn't know how to distribute to that person because they're not their members. And that money, they said, it end up going into the reserve at the end of the day to be distributed internally. We don't know about that process internally, but there are instances that you will pay money which actually doesn't go to the rightful people. The question that we have is that from your side, do you have the list of all members of each collecting society? As you make payment, that this payment that I'm making is going to these members, because allegation that we've received is that there are people whose money is being paid for the music that has been played by SABC or any other channel, but they are not a member of that collecting society, and that collecting society will sitting with the money that they cannot account for it.
So maybe an opinion first, and then I'll answer the question. I think that's probably where we need to spend more time and effort on, because the relationship between the broadcast and the collection society is governed by a legal contract. But the broadcaster has no relationship with the artist. And that's the challenge that we have. So we can't identify the thousands of artists and what they've produced and when they release a new song. Speaking specifically on a TV platform, radio is slightly different because they're keeping pace with tracks in terms of their music programming. So what we've done in what we call today video entertainment, which is the television business of the SABC, is we've listened to these complaints from artists directly, and we've invested in systems to digitally fingerprint all of the content that we get from the rights agencies. So they will submit to us a track list to say, these are all the tracks that we have. These are the artists, these are the publishers, and then we put that onto a system today that actually listens to our broadcast. And if it's more than 5 seconds of a song or a piece of music, it can then search the database and pick up exactly who the artist is, who the publisher is, and it keeps a record of that. So it's something that we've been working on in the background to avoid these disputes going forward, where we feel as the public broadcaster we can do a little bit more than we were previously doing. So that's we've had in existence now for probably 2 years or 3 years or so. it's not without its problems, because we firstly need to get the tracks and the physical track from the music agency and the publisher, so that we can, what we call, digitally fingerprint that.
Yeah.
And that's something that we've been working on. Prior to that, we used music cue sheets, so it was a physical record of what was produced. But that only shows the creation of the content. It doesn't show the exploitation of the content. Because when we broadcast, there's a premiere date, there's a repeat date, it comes back so many months later. So this form of sort of digital fingerprinting is a much more accurate way of accounting for where content is used and who is sort of the beneficiary of that usage effectively.
Is there instances wherein the SABC will make payments without a broadcast usage? What?
It shouldn't happen at all. I can't say that it's never happened, but it shouldn't happen, because we have a legal arrangement, right, with the rights agency. So we make sure, as far as possible, that we really, keep accurate records to avoid such issues going forward. As I said, our departure point is, before we use the content, we make sure that there is a legal arrangement before we start using that content, so we don't sit with these issues. I think probably in the past, when these things just started off, it was kind of, okay, there's a nice piece of music, let's use it and proceed. The same way today, everybody picks up their phone and they film whatever is happening around them without ever asking for permission to film that, which then becomes a copyright issue. So we make sure that we have legal arrangements.
Okay. CEO, this is for you now. What I wanted to check with you is with regard to the transparency within the SABC. The radio department, my colleague here, they prepare the playlist and they send these to them. They provide this information to the societies.
And the artists.
And the artist.
Mm-hmm.
Because what I wanted to check, because our investigation is about transparency and access to information. Is the broadcast usage that you guys collate a private, confidential?
Is it confidential? No, it's not. In fact, my dear brother, they ran out of that forum he mentioned earlier. And that forum is extremely transparent. This is where we share this with the artists as well as the collecting societies.
So the broadcast usage report is actually public can access.
Yeah, it's not a private thing, because everybody needs to know.
So that includes your playlist. It's the same. What's the difference between the broadcast usage and playlist?
Well, in the radio space, it is a playlist.
And then the television is broadcast usage. So even the playlist is the same. There's no
Everything is
secrecy.
transparent.
Okay. And the other issue that I've already asked this question. Just want to check. No. Okay. Chair, through you, Chair.
I don't know what else to say to you.
Advocate Vanilla, you may have to open your laptop again. I'm going to refer you, and I'm coming to the. We're closing.
Call the meeting into order. Let's proceed.
Thank you, Chair. I'm going to request you to check Annexure L.
Maybe if you can read, because I have a challenge opening the annexure.
Okay, so it's in paragraph. Actually, let's check paragraph 35 of your statement.
Oh, okay.
Yeah, it's much easier because I've done my notes already. So,
Paragraph 35.
yeah. We're coming to the end of this.
That looks like we're getting to the end.
Yeah. Are you there?
Yeah.
Okay, in paragraph 35, you referred us to an internal memo. It's dated about December 2016. And in that memo, I will not go into detail about the memo, so I'll just ask the question. There's a reference to a payment of about 19.8 million. I'm not going to mention to where. But what I wanted to check is that, was that payment made? And I'm asking this person, Chair, because we've got a schedule of payments that we receive from the SABC. This payment is not reflected. So I wanted to check if this payment was effected, because I saw the memo was actually approved, but in the payment schedule doesn't reflect.
Yeah, perhaps just to provide context, which we did provide in the statement itself, we heavily reliant on the source documents that we use to construct the statement which we've attached. If it is not reflected, if payment is not reflected in those, it is something that we would have to go verify with the team. I cannot absent our records indicating that there was a payment, saying that there was a payment. What I do see is that even the statement refers to a request for a payment. It does not refer to a payment being made.
Okay, now that's fine. Maybe on that one you can come back to us, look at it and say, because in the payment schedule it doesn't reflect. In closing, what are the changes the SABC will make or suggest should be effected to ensure good governance, transparency, accountability in the music industry?
Look, before the GCO concludes, I'm sure the business owners of video entertainment and radio would want to have a say on this, because they're quite affected by these processes. From my experience, I think the challenge seems to be in this value chain, what happens between the user of the work making a payment of a royalty and the affected owner of the work. And I think, I know there's different kinds of legislation in place. There's different processes to amend legislation. If there is an area to be improved, I think that is an area where we would like to see, if it is not the case, someone being assigned a responsibility to monitor and hold people accountable between the two entities. Because for the record, and I know many people say this whenever an artist has passed on, the blame gets to be apportioned our way. And as the records will show that you're in possession of,
Yes.
we do discharge our legal obligations, except where there are problems, legal problems. And we don't leave those problems to resolve themselves. We do work closely with collecting societies, and at times with the affected owners of the works, to find an amicable way to resolve the challenges. Thanks.
So in essence, you're talking towards the regulatory institution that can facilitate this process?
Yes.
Okay. You want to say something?
All right, in the radio space, what we're currently having a discussion around is something in line with Advocate Vanara is mentioning, a monitoring system so as to eliminate the human element in terms of verifying what has been played and what works belong to which society. Because that's as far as really our responsibility is. If we can provide accurate reports to the societies and have a way of verifying what is also sitting on their repertoire, that it's sitting there rightfully, and eliminate the manual processes of doing these things, and ensure that the reports that we share with everybody are at least close to 100% accuracy. But in terms of what we pay to the collecting societies getting to the rightful recipients in terms of the record companies and the artists, I really don't think that at the moment really there is something that we can say we're getting close to changing there, because I think we also need to look at what the law requires in terms of, the broadcaster. But we are here to engage with the collecting societies and the owners of the works that we use where there are problems. But I think everyone in the value chain should be held accountable for their role that they are performing or not performing. Thank you.
Yeah, I think it's a difficult one. From our experience, the relationship between the broadcaster and the rights agency seems to be fine. It's between the rights agency and the artist. I wouldn't want to open the door for the broadcaster to get directly involved in that. It's too onerous for us to go through that. Remember, on a TV channel, we broadcast more than 1,000 events per channel per day. And that's not even the segmentation that's included. So to go and track, usage of 10 seconds of an audio clip becomes too much of a challenge for us. Also, we're not aware of the relationship between the artist and the rights agency in terms of what they get paid back and those kind of things. But we definitely want to support the industry in terms of information and make sure that we are completely transparent. So from that perspective, we've engaged the industry, and we do keep records as indicated, and we do share those records. So for us, it would be probably understanding where the artists are coming undone and seeing how we can assist from that perspective in terms of information sharing, but not necessarily to have the direct relationship with the artist.
Firstly, let me thank the regulator for affording us an opportunity to share our perspective on this. One, I do think that we need to acknowledge that this is a very complex value chain, and each individual player has a role to play. As the public broadcaster, we are playing our role sufficiently. We ensure that we meet our moral obligation as well the legal obligation of dispersing the funds that are due to the various societies. We do know that there may be challenges when it comes to the next level between the societies as well as the artists. You asked, Chair, through you, Chair. You asked, what are we doing? I think one of the things that we have ensured we do differently is to provide more transparency. This is the reason why we engage quite frequently with the various societies as well as the artists' representatives in the forums that we've created. But to quote Advocate Vanara, we do not want to assume powers that we do not have. We cannot get engaged in a legal relationship between the societies and the artists. Yes, we can get to engage. Yes, we can influence, but there is a contractual relationship between the artists as well as the societies, and we need to respect that. Notwithstanding all of that, we ensure that we have various forums where all of the players can engage us and raise their concerns. But thank you very much, Chair.
Thank you, Chair. Before you come, my investigator here, that the people who do investigations, she just asked me that I should ask this question so that they can cover the gaps. Okay. There's a question about the double dipping. Is it double dipping? Yes. Where people have got dual membership. I think you touch on it. Where people have got dual membership. You mentioned that you normally wouldn't pay. Is that what you said?
Right. Where there is dual membership, yeah, between the two societies, it's one artist or one record company, we send it back to them to say resolve it with the member. So the member will then choose that, no, I want to stay with SAMPRA or I want to stay with IMPRA, and then we pay that one. And where really there is a standoff, we can't pay the money where we don't have assurance that it will get to the next person. But also people would refer to the double dipping, but you would find that there's a very clear separation between the artist and the society, because you'd find that we paid in 2014-15 for the artists under a specific society, and then they changed in 2015-16. So, we would say we were not wrong for paying while you were a member of the other one. Now that you've changed, then it will go to the new one. So a lot of them have been easy to resolve that way, but of course there is a small percentage that is undecided, which we're still trying to find solutions for.
Thank you so much. Chair, I have no further question for, I'm not sure that to call witnesses or witness.
Thank you very much, Mr. Nemas. Thank you very much, CEO, and your team. You may be excused. I will go on for lunch, and we'll come back at 3:15 for the last witness.
Thank you, Chair. I just have one announcement. If I could make an announcement. Thank you very much for staying with us till this time. I just want to make a request that if we could kindly minimize the usage of our devices, whether cell phones and laptops, because we are streaming live and we are experiencing some interferences. So if you could use either or, but not both, and minimize if you're not using it at the time. Thank you very much. We will be back at 3:15. Thank you.
next witness is Mr. Kadi Peche from CIPC, Senior Manager Copyright. Am I pronouncing your name correctly, sir?
Yes, Chairperson.
Thank you very much. You can swear.
Thank you very much, Chairperson. Sir, do you have any? Do you have any objection in taking an oath?
No.
Do you consider same to be binding on your conscience?
Yes.
Please then repeat after me. I swear to tell the truth, the whole truth, and nothing but the truth.
I swear to tell the truth and nothing else but the truth.
Please raise your right hand and say, "So help me God."
So help me God.
Thank you. Witness sworn in, Chair.
Thank you, Chair. Mr. Peche, good afternoon.
Good afternoon, sir.
It's very late, but I'll try to be quick in terms of our answers, our questions. But maybe, Chair, could just do the intro that one of the requirements for granting access to records of private bodies as contained in Section 50, Subsection 1A, is that a requester must be given access to any records of a private body if that record is required for the exercise and protection of any rights. This is covered in my statement, Chair, that this investigation and line of questioning is intended, Chair, to check if under the current legislations, is there any right that the complainant can claim or exercise or protect? So the line of question is based on that. So maybe before we start, maybe if you can just confirm your current position at the CIPC, as well as what role do you play in terms of the royalties concern?
Thank you very much, Chair. I know it's difficult to speak after lunch because the stomach is full, but I will try to do my best. My name is Kadi Peche. I'm the Senior Manager at Companies and Intellectual Property Commission. I deal with copyright matters. Among those matters is regulating or supervising the Accredited Collecting Society for rights in sound recording. I'll refrain from using needle time rights. I will just refer them as rights in sound recording so that I do away with the industry terminology of needle time and stick to the legislative terms. So I'm also responsible for film registration at CIPC. And further to that, I'm also responsible for education and awareness in IP. So we will go all out and start to educate people about intellectual property, including the creative sector itself, so that they are aware of their rights and their responsibilities as right holders.
Thank you, Chair. Thank you so much. So this is obviously part of your job. As you're answering questions, you're also doing awareness in terms of copyright. Thank you, Chair. Whilst preparing for this hearing, I managed to get hold of your presentation relating to the copyright to the Portfolio Committee on Trade and Industry Subcommittee. And the purpose of that presentation was to provide response to the key issues raised by the stakeholders on policy positions as introduced in the Copyright Amendment Bill. So in that presentation, the CIPC submitted that there are 5 collecting societies in South Africa. I understand that the number has increased to 6. Can you please take us through those entities?
Chair, are you referring to all of them or only accredited collecting societies?
All of them. Will go into the accreditation just now.
Yeah, let me try to go and... To my knowledge, Chairperson, we have SAMPRA, that is accredited by CIPC. We have IMPRA, that is also accredited by CIPC. These 2 collecting societies are accredited to administer and to manage the rights in sound recording. They have a license to run their business from CIPC. Then we also have CAPASO,
that is not accredited by CIPC as we speak. Then we have SAMRO, that is also not accredited by CIPC. We also have RISA and ECHO that are also not accredited by CIPC. So much of my testimony today before this hearing, I'll speak much from the rights that I'm regulating, because that's where I have depth information.
Thank you, Chair. Chair, Mr. Peja, you mentioned about 2 accredited collecting society, and is it 4 which are not accredited?
Yeah, it's CAPASO,
Yeah.
it's SAMRO, it's RISA, it's ECHO, so yeah.
It's 4. Okay.
Correct. It's 4.
Thank you so much. So I want to refer you to Section 5, Subsection 3A of the Performance Protection Act. You don't have to open the Act. I'll read the sections for you. So A and B provide as follows. 5.3 A and B says the amount of any royalty contemplated in subsection 1B shall be determined by an agreement between the performers and the person who broadcasts or transmits or causes communication of the performance, as the case may be, or between their representative collecting societies. So I want you to underline their representative collecting society. And then subsection B says, in the absence of an agreement contemplated in paragraph A, any party may refer the matter to the Copyright Tribunal established in terms of section 29(1) of the Copyright Act, or the parties may agree to refer the matter to arbitration in terms of the Arbitration Act. I'm sure you were here, you had asked this question to the SABC about the tribunal. But if you can hold into that section, I want to link it with section 9A. It also deals with the royalties, but this one is section 9A of the Copyright Act. So the 5.3 is Performance Protection Act. Now I'm going to 5A, 1B. It also says the amount is similar to that. If you look at it, it says the amount of royalty contemplated in paragraph A shall be determined by an agreement between the user of the sound recordings, the performer, and the owner of the copyright, or between their representative collecting societies. So both Copyright Act and I need to get this word properly. Performance Protection Act, they talk about a representative collecting society. And then I'm now going to refer you to the collection society regulations, which is what you actually, as the CIPC, you guys are managing that. And that's regulation 2. It deals with the scope of regulation and provide that a collecting society it says the collecting society regulation set out the conditions under which a collecting society may be established. So these regulations set out the condition under which a collecting society may be established and may operate, but under those 2 provisions that I mentioned earlier on, 5.3 and 9A. What is your understanding of this scope of the collection society regulation insofar as the establishment is concerned?
Well, if you can look at the sections that you have just referred, the one from the Performance Protection Act and the one from the Copyright Act, they establish a mechanism of collective management of rights in sound recording. Then the regulations, they give the implementation phase. That's what the 2 statutes do.
So my other question is in terms of, is there any representative body that can be called a collecting society if it's not accredited?
Yes, if you can look at how government approached this, they made a policy position to say, for now, we are going to require accreditation if you want to administer or manage rights in sound recording only. Others, they were left unregulated.
And what was the reason for that?
Unfortunately, I'm not a policy maker. The DTIC is the one that formulated this policy, so I guess they have provided written submissions, and I hope they've also ventured into why they chose only rights in sound recording.
Okay. And
I'm just the implementing agency of the department. So they hand over legislation to me, then I implement.
And as the implementer, do you feel that decision protect those who it was supposed to be protecting?
I guess they have already seen a need to regulate all forms of collecting society because I'm told it's part of amendments in the Copyright Amendment Bill.
Okay.
So they have seen the need.
Okay, we'll come to that shortly. And then I'm going to refer you to Regulation 3 of the Collection Society Regulations. It prescribes the required threshold of rights holders on whose behalf the collecting society may be accredited to administer the rights. What are the minimum threshold of that anyone for anyone to be accredited?
Chairperson, let me start by saying, and this is just a personal view. When I look at the regulations on collecting society for these rights in sound recording, I see them as light touch regulations. They are not very specific as to what should happen when an applicant lodges an application, even on other matters where CIPC has to step in and regulate. So then it leaves much to divergent interpretation. So when you look into how other jurisdictions have crafted their regulations on collecting society, you find them, and I'll use the term militant in a way. They are very specific, shall or will instead of may. So in my view, they are light touch regulations. So your question is?
The minimum threshold.
Yeah, minimum threshold is the applicant must at least administer 50 or more either performers or copyright owners and performers jointly for that person to come and lodge an application for accreditation at CIPC. That is the minimum threshold.
Okay. I know this question you might have answered, but I just want to make it clear. In your understanding of the regulation, can any person or organization be recognized as a collecting society if not accredited by your office?
Insofar as for rights in sound recording, that person cannot. But for other rights, they are at liberty to do so.
So the collecting society for sound recording royalties must be accredited.
Correct. Hence the policy position taken.
Can therefore a collecting society that collects for sound recording, is it allowed to collect if uncredited?
That's why I'm saying if it's not accredited, it cannot be allowed to collect.
Maybe
the unfortunate part is that there are no criminal sanctions for any person who attempts to do that or who does that.
Okay, and then, but if you look at Regulation 4.1 of the same collection society regulations, it provides that the registrar shall exercise a supervisory function in regard to the collecting societies in accordance with the Copyright Act and the Performance Protection Act. And this regulation can the registrar exercise supervisory function over an accredited collecting society?
Unaccredited?
Yeah.
No, because I can't imagine the legal framework that the registrar will use in that regard, because registrar is limited to only those that have been accredited.
So you talked about the two collecting societies that are accredited and 4 that are not accredited. Are you aware if any of the 4 that are not accredited, if they're collecting for sound recordings?
I'm not aware. As far as I know, they do not collect for rights in sound recording.
Okay.
They collect for other rights.
Then maybe one of the people that we can ask here, audience, is to say, but what are the advantage and disadvantage for being accredited?
And I think Mr. Leroux answered this question very eloquently to say, one, when you regulate any sector, the first thing that you will get, you will gauge whether policy positions or objectives formulated in that sector are indeed realized. That's the first thing that you will gauge as a regulator. But being specific to these rights in sound recording, one, of course, will get the benefits of at least get accountability, force good governance from these agencies that are collecting. And lastly, make sure that indeed the people who create do get their dues from their works. Because one of the philosophy of intellectual property is that it rewards and incentivizes those who create and innovate. That's its foundation. And as an implementing agency of the DTIC, we must make sure that we put or line up our resources, our effort to make sure that indeed intellectual property at the end of the day rewards those who create and innovate. But we must also see intellectual property as a system that also gives something to our society in terms of information and other forms of development. You can imagine if there were no textbooks from those authors, education was not going to be easy. So we must make sure that those people are able to reap the benefits from their creativity, from their innovations.
Yeah.
It's in our mandate, it's inherently in our mandate. Hence, another function that we perform is to go all out and educate people about IP and sell its benefits. And that's what we are trying to do.
Although the regulations does not compel, according to your evidence, the collecting society which are not collecting royalties for sound recordings, is there anything that prevents them from being, to apply for accreditation to ensure good governance and accountability?
I'm saying they can apply for accreditation only in sound recording rights.
Okay.
But they can't apply in other rights because CIPC is not currently mandated to entertain those kind of accreditation applications.
Okay.
But it must be emphasized that these collecting societies that are not accredited by CIPC, they are using the corporate law regime. And members are at liberty to invoke their rights under the copyright, the company law, especially during annual general meetings when financials are tables and other business affairs of a collecting society. They must invoke their rights. And we have seen that not forthcoming from the members, and it's a challenge.
Yeah. In terms of your supervisory powers as a regulatory body for the sound recordings, what powers do you have over accredited societies? In other words, what is it that you can do to ensure accountability?
Well, again, I will go to that point to say, when I look at the regulations on collecting society, I just said they are kind of light touch regulations, and they are therefore open to different forms of interpretation. As a regulator, I might say I'm entitled to get the bank records, banking statements from the collecting society. And the collecting society can come and say, show me where it's written in the regulations. So the regulations sometimes do not pronounce in black and white what the registrar can demand and what the registrar may not be entitled to. So That is why there is a drive to review them and see how, from our experience, we can better them.
So I've picked up in the regulations that one of the powers that you have will be you do attend the AGM. Am I right?
Correct.
And there's an issue about the financial statements. I'm not sure if I'm correct about my recollection is correct. Do they submit any financial statements to the CIPC?
Yeah, they do submitted audited financial statement. That's what the regulation is demanding from them.
Yeah. In your view, what do you think the legislature would have put that requirement? Let me say the minister this time, because regulations are done by the minister. What do you think the intention would be in terms of your supervisory power when the financials are being tabled with the regulatory body?
I think the regulations should be very clear to say the registrar shall be entitled to launch any form of investigation, just to ensure that indeed the money reached the beneficiaries. And it should be couched in peremptory language, in my view. And that's the core. Other things we can talk about, but if the money indeed does reach the beneficiaries, then we have fulfilled the philosophy of intellectual property, and our people can be removed from being impoverished.
Yeah. Obviously, the CIPC, you do know the challenges that it's been reported on a daily basis regarding some of the musicians who their rights of access to information, including rights to royalties, that they make obviously those allegations that they're not being paid. When you have you ever, maybe let me rephrase the question, have you ever conducted an investigation as the regulator?
Yes.
And if you can give us an example, what was the outcome of that investigation?
And I just want to caution this hearing to say, sometimes we judge things from far without having to excavate the truth or the true facts. There was a complaint from 2 musicians that we received. And one of those musicians was saying, I have received more than I was entitled to from Collecting Society A.
Oh, wow.
Then the other one was just dealing with something that does not relate to right and sound recording, and we have to do education and awareness to their lawyers. So I'm just saying, before we judge situations, we need to get facts straight. And for one to complain about his or her royalty, the first relevant question that person must ask himself or herself is, was there usage?
Yeah. But then the question is, how do they get usage if they're not being given access? How would they prove usage if they're not being given access to their usage, broadcast usage report?
Chairperson, I submit that access to information is critical, and I don't have to overemphasize it. It must be obtained so that these people can know whether to defend or exercise their rights.
One of the, I think there's, I hope I'm right about this. When I was preparing, I heard that there was a complaint that was ever lodged with the CIPC. Maybe I may not have the facts now, but you end up not investigating a complaint. Do you have backlogs of complaints regarding the rights of these people's royalties?
No, we don't have backlog, and our approach is very simple. When a complaint is lodged with us, and I think this is just fair, we will inform the complainant to engage a collection society first, so that internal remedies are dealt with first. And if the party still feel aggrieved, then the issue is escalated to us, then we have that tripartite kind of a discussion, and then we resolve the issue. But there could be situations whereby the party is still aggrieved after we have dealt with the issue. And under those circumstances, we should allow that person or party to exercise his or her rights constitutionally. So,
yeah. So you mentioned about the powers that you have to conduct an investigation. And the question that I have is that what recourse does the CIPC has against an association which are collecting royalties while not accredited? But they are collecting for sound recordings.
Well,
As a regulator.
I don't think we have any remedy that we can invoke there, because when you look at the regulations read together with the Performance Protection Act and the Copyright Act, there is no penalty leveled against somebody who collects rights in sound recording without accreditation.
Is there anything that prevents the CIPC to take, as a regulatory body, to take that particular representative body that is not accredited but collecting the sound recording royalties to court so that the court can interdict them?
I'm yet to be advised so that I can be shown the section, the provisions that I can rely on before I go to court.
Yeah. Okay, then let's come to the issue administration fees. You've heard earlier on the evidence, I think from the TUMSA, the union, also evidence from the Department of Sports, Arts and Culture. They give evidence about the administration fee. Actually, Department of Arts and Culture, they put that under their common problems, under the music industry. And TUMSA also raised an issue that as far as about 40% administration fees being charged in royalties that are being collected. So earlier on, I refer you to the presentation that you guys made in Parliament. And one of the things that you mentioned was the issue of, you do the comparison in that presentation. I'm not sure that Tim, you shared with him yesterday, the presentation. Did you? There's a presentation that I'm not sure. Do you remember the presentation that you made, I think in 2018?
Yeah.
But when you're preparing for Amendments Act.
Yeah, the one that we did before the subcommittee.
Yes. Before the subcommittee. So in that presentation, you also mentioned about the high administration fee that the collection society does charge in that presentation. You specifically even mentioned the name of the entity. I'm not going to mention it. It's over 30% that they charge. But today we have had evidence that they go even almost 40%. I wanted to hear your view in terms of the collecting society regulations. What is the prescribed maximum administration fee that a collecting society must charge?
Well, and I will speak for rights in sound recording only. The legislation is allowing at least 20%. And it is our view that once a collecting society starts to improve, it must be able to minimize those administrative costs, because in certain instances they can even use technology to take the cost down. But I cannot sit here and say 20% it's fair or it's not fair. But what I can tell is that over time a collecting society should be able to take its cost down. And that will, in my view, benefit the beneficiaries, because this is their money. They have just mandated the collecting society to license, collect, and distribute to them. So the money belongs to them. It's their works. And that's what we should always have in our minds.
You in that presentation, you made a comparison in terms of other international bodies. I think you made comparison with the UK, if I'm not mistaken. And I think the average there was between 10 and 24%. Is that correct? What was your finding when you do the comparison of what we charge compared to other jurisdictions?
I don't recall really making that comparison, but I mentioned in my memorandum that we haven't really performed a benchmarking study with those two countries, US and UK. And also to mention that in USA, they do not have these rights in sound recording per se. So for purposes of rights in sound recording, USA is out of the picture in my view. I know UK does have it, but we haven't performed benchmarking study there, and I don't want to talk about something that it's not done.
Yeah. Earlier on, you talk about, you addressing the chair and said you cannot overemphasize the importance of the right of access to information insofar as the payment realities are concerned. One of the questions that or issue that has been raised with us is the issue relating to the payment. When sometimes the musician says they'll just receive a payment of 3,000 into their account, and nothing is being said about how that amount has been arrived at. No statement, nothing. As the regulator, what is your comment on that?
Well, before I I pronounce on the regulator's view, I think it's important for members of different collecting society who are the right holders to raise these things in their annual general meeting, to say, we want to get statements reflecting how much we have earned insofar as our royalties are concerned, so that they also take responsibility of invoking their rights. Because there are remedies in law. Company law does empower them to raise those issues and mandate the collecting society or that management body to do things in accordance with their needs. But from a regulator's perspective, we think the law must be very clear in terms of the powers that we should have, so that we should not have situations whereby sometimes this collecting society will even take us to court. If the legislation is very clear, things are in black and white, you can even show them why you are doing certain things. So the legislation must have the teeth to bite where it should bite. And it can even avoid divergent interpretations when the regulator is exercising his or her regulatory function.
Yeah, I'm going to ask this question in terms of if a member, and I want to give you a view from the regulatory perspective, a member of a collecting society, do you believe they're entitled to get access to the records for them to check whether there's any of their royalties that have accrued which may not have been paid?
And that's the core of accountability and good governance. So they must always be entitled to that kind of information. Hence I said that will enable them to exercise or defend their rights accordingly.
Yeah. Okay, Chair. Okay.
Things that he does at his level. I think if he was to be a minister, a lot of problems could be solved. An issue about those that are not accredited. As a regulator, the sweetheart approach will not work. You must be able to hold people accountable according to company law.
Thank
you very much. And I'm still going to repeat to say, can you please bring those statements to us in writing? And you are welcome to come to our office. We want that information.
Chair.
I'm not threatening you.
Chair, I'm going to request if, Mr. Peter, if you've got anything that you want to share with us
Yeah.
as part of our investigation into the issue of good governance, transparency, and access to information to assist those people, especially those, the vulnerable one who require access to information for them to access their rights to royalties.
And thanks, Chair. I'll borrow much from what the CEO of SABC said. System of collective management of rights is a very complex system because things are interconnected. Different types of rights are compressed into one document, and they yet require that intellectual know-how of disentangling them so that we can also demonstrate their separate existence. So we need to trade carefully because there are a lot of explanation, education that we must do in this sector. Also, given the fact that we are still a developing state, not to mention the education or the level of education that we still have to improve in the creative sector itself. So we need to have some partnership working model where regulators should also be able to share information, discuss things, so that we are on the same page with each other. So I just want to say it's a very complex system. We shouldn't be hard and harsh to ourselves sometimes.
Thank you. Thank you so much, Chair. I'm about to apologize to you, Chair. I've already said I'm closing, but I just realized that I forgot one question, very important question. Thank you, Chair. It's the question relating to the Copyright Amendment Act and the Performance Right Amendment Act. I would not have done justice for you to leave without sharing with us and the public as to what are the key issues that you can highlight that these amendments are bringing to them, at least to bring some joy to them.
Unfortunately, it's not my area of responsibility. And I think DTI has made detailed submissions on that, reflecting the policy objectives and the intentions around those policy objectives. So I think they are more suited and appropriate to take you through that journey, unfortunately. I'm just implementing what they give me. But one statement maybe that I can just echo is to say the current Copyright Act is obsolete, it's no longer relevant to today's business model, and it requires overhauling.
Thank you so much, Chair. No further question, Chairperson.
Thank you very much. Thank you very much, Mr. Peter. I'm going to adjourn the proceedings for today. We are continuing tomorrow at 10 o'clock. So we'll see you tomorrow. Thank you very much. Oh, CEO, I'm so sorry. Sorry. I forgot to say, I just made a ticket. I think it is done. Sorry, CEO, you can come and do the closing. Thank you very much, Mr. Dean. Thanks,
Thank you very much, Program Director and the Chairperson of the public hearing. Ladies and gentlemen, mine is a very simple task, really. Chairperson, I don't envy you to be chairing here, to be facing all these important ladies and gentlemen. There have been moments where it was a bit tense. There have been moments where there was laughter. There have been moments of us being very, very serious. So I don't really envy being sitting here where you're sitting, Chairperson. But mine is a simple task, to thank everyone, to thank colleagues. It's a two-day public hearing. We're continuing tomorrow. I'd just like to thank everyone who has participated for day one, starting with the generous accommodation we've received from the Nelson Mandela Foundation. It's indeed a legacy that Madiba left for all of us to come here and deal with these very, very difficult issues facing our society, our industries, our musicians. These are difficult issues, but they've got to be dealt with, they've got to be resolved. So I would like to thank the Nelson Mandela Foundation. I'd like to thank Advocate Weapon for the opening address on behalf of our chairperson, Advocate Kakula. Thank you very much, Advocate, for setting the scene and the tone for these discussions. The chairperson of the day, Advocate Lebogang Zama. Like I said, I don't envy you, but you've done well. You've done well, really, because at a point where I felt you should have been a little bit harsh, you calm us down. You say, no, I'll give you a chance, wait. You never really say, no, you can't talk. You really allowed some form of participation. So thank you very much. The evidence leader, Mr. Namasisi, and your team for the preparations. Thank you very much. We needed this kind of engagement, the kind of questions that have gone into this. Sometimes when you're not a professional in a field, and you look at other you seem to think it's easy. But every day I realize how difficult it is to become a lawyer. Just it's another world. And for the years I've spent with lawyers, it's almost 18 years, I've come to respect them, because I don't think you can be a lawyer without thoroughly preparing yourself. Preparation is key in being a lawyer. Reading, understanding and interpreting things. I think it's very, very key, and it has come out in these hearings today. The evidence that was presented before this hearing by different presenters, it's welcomed, because this is an investigation. From the Department of Sports, Arts and Culture, the representative of the DG, we thank him very much. The union that is representing the musician, we thank him very much for the input he's made in the form of evidence. The CEO of the SABC and the team for the response they gave to the hearing today, and lastly to Mr. Peche for answering the question. I must say, on a very, very light note, they say dynamite come in small packages. Mr. Peche, when he sits and sometimes we may just undermine him. And I'm sure some of us who have heard him expressing himself here, for me, he's a dynamite. But without all of you, those who are watching, those who are in the auditorium here, without all of you, without the staff of the regulator who prepared for this day, both in the professional side and also in the support side of things, without all of you, this would not have been possible. So we thank you very much. But without the members of the regulator for allowing us to have this, when it was presented to them, we thank them very much. It's still day 2. I'm not closing anything. The chairperson will have the last say, but it will be not, I would not have done my job if I do not thank Mr. Timba and team for program directing this, for communicating the message that we are having these hearings. Thank you very much. As usual, they really do well. And to all of us, South Africans out there, it's not yet uhuru. They say Ogenga says it's not yet uhuru. It's not yet freedom. It's freedom because you can vote. but it's not at freedom because you have not solved all our problems. If somebody is still going home hungry, if somebody is still not getting their royalties, somebody is losing a job, if somebody is being killed, all these things indicate one and one thing only. It's not at Uhuru, so there's still a lot of hard work to be done. So on that note, I want to thank everyone, and thank you very much.
Thank you, Mr. Musala. Chairperson, please allow me to make some announcements before you adjourn the session. Ladies and gentlemen, friends, comrades, and colleagues, tomorrow we will kick off at 9:30. Please do be here in time. Tomorrow's evidence will be coming from the complainant in this matter, being Mr. Clive Hadwick. We will also hear evidence from the respondents in this matter, being Ravi, the collection agency. We will also hear additional evidence from an expert in the sector, Dr. Graham Gilfillan. And then we will see who else the evidence leader will let us know.
We also have Eugene Tetra.
Of course, yes. Mr. Eugene Tetra will also be presenting evidence tomorrow. So please do be here on time tomorrow and do study the rules of proceedings for the session. Thank you so much, Chairperson. Over to you.
Let's not ask questions from the audience. Let's just, if you want to see something, put it in writing and just submit so that we don't wait 24. Please, I beg you. Allow for no. My team must just give this gentleman a copy of the rules.
Yes, we will. We will. He'll read it overnight.
But nonetheless, thank you very much for your participation and your presence. We'll see you tomorrow at 9:30 sharp.
Thank you.
Mr. Nemesis, I want to see.
You will take chances, right? It's fine.